After reviewing much of this material at multiple school boards in the Lower Mainland, which someone kindly sent the material to me, it is much of it is unsafe, inappropriate, and some of it is just of very low literary value. And so I'm going to talk about some ways you could object to this material, because I can see certainly how it would offend certain religious groups, certain freedom of conscience, could interfere with parental rights, and may be suggesting that sex is something that young people can engage in with no consequences, which isn't true no matter what your religious affiliation. Sex can be dangerous, it can have consequences, and it may be inappropriate, regardless of whether it's illegal.
Drea Humphrey here with Rebel News, and beside me is Karen Bastow, a lawyer with David G. Melbourne Trial Lawyers. She's a great criminal defense lawyer, and we're going to be talking about an issue that many of you have reached out to Rebel News about with your concerns, and that is the sexually explicit books that are running rampant in schools today, and what action, if any, especially legal action, can you take if you are concerned about that? Recently, I brought you a report about a board meeting, a school board meeting from Chilliwack, BC, District 33, that has sparked outrage on social media from concerned parents because many of the people who posed questions during the public participation portion of that meeting were shut down and censored for asking certain questions. And a lot of those questions had to do with what is the law in this area? Are the kids looking at pornography? Can we take legal action? So you're not going to want to miss a second of this report. And if you appreciate that Rebel News covers these important issues, then please consider supporting our independent journalism that is not backed by the Trudeau government like 95% of the media in Canada. And you can do so by going to rebelnews.com and clicking on the donate button. You're probably going to discuss SOGI 123. So for anybody who's not familiar with that, that is a sexual orientation curriculum that's sort of a fluid curriculum. It's not like there's a certain week where it's discussed and parents can say, hey, I'll have my kids in school that day or I won't. It's something that runs throughout the whole year and has caused a lot of concerns, especially for people who feel like it's really pushing gender ideology on kids. So you're probably going to mention that. And I just want to let people know some of the work that you've done. I know you've worked on defending criminals who've been accused of some very bad things.
Yes, and I've defended many people accused of sexual assault, child sexual assault. I've done child pornography cases. I haven't actually gone to court in any of them. I've had an opportunity to look at a lot of child pornography. The rule is they keep it at the police station and you have to go there and look at it. Sometimes they give it to you, but they don't like you to keep it. You have to destroy it. And I do have a sense of what would meet the criminal law test for child pornography.
And that's one of the questions and concerns many of you have, myself included. Are these teachers, these librarians showing pornography to children when they're seeing images like this? I certainly don't think that these books have any place in a school. But when I look at the definition of pornography, I see that there's that word of intent. Is this material produced with the intention to elicit sexual arousal? What do you think about that?
Well, my reading of the criminal code is that it is all about intent, and the material has to be produced and utilized for a sexual purpose. And I don't think, and actually, to be clear on that, in the case of child pornography, the sexual purpose has to be that of the adult. So I don't think that this material raises itself to the standard required to be prosecuted as child pornography. I do, however, think after reviewing much of this material at multiple school boards in the Lower Mainland, which someone kindly sent the material to me, it is much of it is unsafe, inappropriate, and some of it is just of very low literary value. And so I'm going to talk about some ways you could object to this material, because I can see certainly how it would offend certain religious groups, certain freedom of conscience, could interfere with parental rights, and may be suggesting that sex is something that young people can engage in with no consequences, which isn't true no matter what your religious affiliation. Sex can be dangerous, it can have consequences, and it may be inappropriate, regardless of whether it's illegal. The reason pornography is so narrowly defined is because our civilization has a history of book burning. And we don't want to go back to a history of book burning. We need to be liberal about literature, written literature, visual literature, for the purposes of protecting our traditions in art and in education. We don't want to go back to those old ways of burning books that we consider disagreeable. We need to maintain an open society. So the situation with these books that I see, really what has happened here is this organization called SOGI 123 in 2016 were sort of given the educational resource contract by the provincial government. And since then, this group has produced a lot of educational materials. It's almost like they're pre-approved because they have the contract, and they're an independent organization. They're not a government organization. They're not the Ministry of Education. And so there's been a plethora of literature produced under the auspices of this policy since 2016, and we don't really have any way to assess its suitability or to judge it because it's really almost pre-approved. So the boards are not approving these resources one resource at a time. They're given a list of resources from SOGI 123, and I think another organization called ARC is also involved, from which they can choose resources, and therefore the resources are considered pre-approved. And what really has to happen is there has to be a broader social and community discussion about what we find acceptable from the perspective of community standards for children in this age group.
What legal stance has the superintendent taken in regards to the criminal code? Let me just briefly read. There are strict definitions as it wasn't considered child pornography.
So I'm turning off your mic, Dr. Ferguson. Yeah, we're not doing this. There's no illegal material in our schools. That's highly defamatory. No, I'm not going to let you. Sorry. Too bad. No, it's not true. There is no illegal material in our schools. It is not a thing that is happening. So you can have a seat now. Thank you.
But you did mention proper channels. So what exactly are those proper channels that parents can take to take action if they're concerned about this?
Okay, so I see this as a new area of literature that's been developed to fulfill this demand that we provide sex education in the schools. So it hasn't been considered very much. So as an individual parent, what the parent wants to do is identify the resource, and that means the book or the literature in the library that's being used, make a copy of it, look at it, and then set out a list of ways that this resource offends them, or they don't, the reasons they don't want their child being able to access this resource, or being, encouraged to use this resource, or forced to use the resource in the classroom. And in the context of doing that, they need to set out, for instance, how it offends their particular rights. So, for instance, for, let's say, certain religious rights, you would say it offends my religious rights for my child. You would say it offends my parental rights. So, United Nations has recognized that parents have an inalienable right to determine how their children are brought up. And this right gives them the right to, not control schools, but to have input into schools and to exempt their children from certain types of education, and to have prior notification when certain types of education are taking place, and to have the opportunity to offer alternatives to the type of education that's taking place. The United Nations has recognized that parents do have rights, but they have to be clearly delineated at the first instance. And that means at the school, you get the resource, you write your letter, you address the teacher that's using the resource, the principal, the teacher librarian, you address it all to them. They will respond to you. If you're not satisfied with their response, they're not going to remove the resource. Then you go to the school district and you say, I'm very dissatisfied with this resource. Here's why. The school district will say yay or nay on the resource. And if they say, we're satisfied that this resource is safe for the school and we dismiss your concerns, then the parent says, okay, I'm going to get a judge to look at it, and you can seek judicial review of the school's decision. This is one of the few ways that you can get a consideration of these resources into a court. Because the problem with the law, and I've looked at the law of about 4 lower mainland school boards, is that historically, like a long time ago, the way it was is that the school board itself would decide what resources could be in the schools. But now the legislation is that any teacher can bring in any resource that they consider appropriate. And so there's no real mechanism to control all these resources. And SOGI resources are pre-approved, but they're not pre-approved in the sense that usually means. It doesn't mean SOGI creates a resource and someone in power looks at the resource and decides it's okay. What it means is that if SOGI produces it and it's on their list, it's okay. Nobody in power has looked at it other than SOGI. So the only way to get a discussion of these issues into the public forum really is to bring a judicial review. And in order to bring a judicial review, you have to take every step along the way and give every level of the educational system an opportunity to respond to you. And this has to be done at each school board. All the school boards and parents can work together to do this, because the process for crafting the argument for every school board is going to be the same. And then a judicial review is a paper hearing. Like, there's no need for witnesses. It's just your legal arguments, and you could put in an expert report on why this might be bad for kids. Some of these materials for some of the kids, I think certain types of kids and certain types of communities would be inappropriate and unsafe. But I don't think they're pornography.
Now, you mentioned that you had the opportunity, or you took the time to really look into around 4 lower mainland school boards. I'm assuming one of those was Chilliwack, based on one of the reports that I've done in depth about parents who had some concerns about these issues and then felt like they were being shut down trying to convey them.
Many of the books that are gender identity are far from the highest quality and inappropriate for children in nature, and even promote sexual abuse and incest, such in the
Sorry, I have to interrupt you. That's not correct. They do not promote sexual abuse or incest. That is not true. Yes, I have actually. So no, that is not promotion. So I'm sorry, I'm not going to let you imply that there are books in our library promoting incest.
Now we know there is the path of working towards putting all your ducks in a row to get to a judicial review if you don't get the answers you want. But what about the parents who are trying to speak and then getting shut down, maybe being told they're on the path of being discriminatory? Did you have a chance to look at any of the rules of conduct during such a meeting?
Yes, I did look at that, and I do think it's very inappropriate for people to be shut down at a school board meeting. They should be given the right to air their concerns, and an insistence that they know exactly what the law is or be referring to the correct law by the chair of the meeting is unfair, because these people are not lawyers. They may refer to the law that to them seems to best reflect their concerns. It may be incorrect to refer to that law, but they should be given an opportunity to air their grievances. We have to remember that school board trustees are elected officials. This is not a sort of forum at the principal's office. This is a forum where elected officials we put in office are making decisions, and nobody should be shut down for referring to perhaps the wrong law. Even if they're wrong about the law, they're entitled to bring that law to the attention of other trustees. They're entitled to bring their concerns to the attention of other trustees. And it's not active discrimination to state your views. Discrimination is when someone comes for a job and you say, well, I'm not going to hire you because you're X, maybe because you're gay, let's say, because that's the issue, or because you're disabled, or because you're Black, I'm not going to hire you. That's discrimination. Or I'm not going to rent you an apartment because you're this, or I'm not going to let you into my law school because you're this. Those are examples of discrimination, expressing your views in a free society. And I refer to Chamberlain, the case in the Supreme Court of Canada, where the court said people are free to hold whatever views they want. And they have the right to do so under Section 2B of the Charter, religious freedoms and freedom of conscience. They can hold those views. What they cannot do is actively discriminate as a result of holding those views. So my opinion is that in the context of a board hearing, people should be free to express their views. This is an elected group. This is your forum, and it does need to get out into the open. There needs to be a discussion. This is new. It's just started in 2016. The explosion of sexual education material has just begun. It's all been created to fulfill this void. There needs to be an examination of this it's almost a new area of literature, and it needs to be examined, and it should be done both publicly and also judicially.
Well, thank you. I guess, is there anything a parent can do if they do find themselves in a school board meeting where they're shut down and accused of being potentially discriminatory? Is there any sort of action they can take at that point?
Well, I think the parents should insist that they're not discriminating against anyone by expressing their views. They should say, well, I haven't refused to give someone a place to live or a job or entrance to a school. I'm simply expressing my views from my conscience, because it isn't discriminatory to express views. That's not the legal meaning of that word.
Well, there you have it. Karen Bastow, sharp criminal defense lawyer, filling us in on some information. Might not have been the information a lot of us wanted, but it's what we needed to hear. Let us know what you think in the comments, and I will link your information, of course, if you need a good lawyer. In the description box below, there is a written article linked there for you to take a look at. Thanks for being on Rebel News.
Thanks, Drea.
If you appreciated this report and you want to find out another way you can take action, you can go to our special website called stopclassroomgrooming.com and sign our petition there to stop educators from asking very young children in elementary schools to disclose their gender identity as well as their sexual orientation. If you want kids learning about ABCs and numbers instead, go to stopclassroomgrooming.com. And if you appreciate our journalism, you can also click donate while you're there.